Good evening, good afternoon, and good morning to those of you who are joining us from the various time zones, because I did get a little peek at some of the people joining, and we have people from around the world, and we're delighted to have you joining on DRBF in looking at dispute boards in the Nordics. We had a general session to kick this series off in February, looking at dispute boards in general and learning about them and placing them. Then we started looking more in depth in by country roundtables. Last month, we had our first country roundtable looking at Norway and what they do with dispute resolution, alternative dispute resolution. This month, I'm delighted that we are focusing on Sweden. Being Sweden is my newly adopted home. And so I feel particularly delighted to be doing this this evening in the roundtable in Sweden. What we want to do is, after this introduction, today we want to explore the uses of dispute boards, or more broadly, alternative dispute resolution methods in complex transactions. We are joined by an esteemed panel today: Jürgen Almelev, Dr. Christina Romberg, and Kai Müller. And I would like each of them to introduce themselves, because while the CVs are on the website, but I want to give a chance to have you get to know them a little bit more personally. So I'll start with you, Christina, turning the floor over to you for an introduction.
Thank you very much, Aisha. I'm Christina Ramberg. I'm a professor of private law at the Stockholm University, and I work a lot outside the university as well. I used to be with a big law firm. I've been at the appeal court, and I am very frequently acting as arbitrator, and some few times also as a mediator.
Thank you, Christina. Jürgen, over to you.
Thank you very much. My name is Jürgen Almelev. I'm a lawyer, and I started my legal career in Norway, actually, working there for 7 years, where I focused on maritime and offshore related matters. Now I've been in the largest Swedish law firm for many years, but now I have a small law firm together with a few colleagues. I've focused on both commercial law and arbitrations through the years. I have done a number of arbitrations, mostly in the shipping environment, typically shipbuilding contract disputes. I've been arbitrator as well. I've been involved in various types of functions in arbitrations. I would say that I have limited experience concerning education and mediation. I've run across it, but rather rarely. So in that sense, I have a handicap, but at the same time, I think it's could possibly bring something positive to the discussion, because many of you panelists know much more about this area or this field than I do. To me, it's still a bit of a question mark why you use it, when you should use it, how you should use it. I have some thoughts on this.
Jürgen, I don't think we could ever say that you're handicapped. The breadth and depth of knowledge you bring to this table, this virtual roundtable is immense, and we're delighted and we're very lucky and honored to have you. And I think that is the key focus of this session. You've highlighted it, that dispute boards, while widely used, possibly in certain industries and certain regions of the world, they're new in many places. And that is our purpose here and in the whole series, to introduce adjudication and the use of dispute boards and what they are and the possibilities and the contours. So I think this is a perfect fit. No handicaps. Kai?
Yeah, thank you, Aisha. So hello, everyone. I'm Kai Müller, and I should start that I'm saying I'm not a lawyer in this group. So I'm head of export for Sweco Group, which I think is Europe's largest engineering and architectural firm. And as such, of course, we serve a lot of projects and a lot of employers and a lot of contractors in the construction industry hopefully before we run into problem and have possible claims and disputes, but unfortunately also we are advisors to the parties when in a dispute adjudication process. My head of legal tells me I cannot advise in an arbitration sequence because we don't have professional liability insurance for that stage. So my services stops with the adjudication board advice services.
Fantastic. And so I think we're starting to get the picture between the panelists, Christina, Jürgen, and Kai. We have a variety, diverse experience, but they kind of all have various experience in the spectrum of the possible dispute resolution. Christina mentioned mediation. Jürgen has a wide view in transactional and dispute resolution in maritime, and mentioned a lot about arbitration, and Kai talked about adjudication. But to set the stage about this spectrum and about the use of possibly preventing disputes before we have to resolve them, I'd like to turn to the lawyers, if I may, Kai, and ask Christina first, and then Jürgen to kind of add to this about if you could help set the stage for us about the use of dispute prevention tools, if at all, in Sweden.
Well, yeah, I'd say that it is a bit misleading, the term dispute resolution boards, because it gives you the association that it is some kind of arbitration or litigation in court. I'd say it's not. You cannot, by this decision, get enforcement by the authorities. And it's not really, well, it can be mediation in the way that this board, the decision makers, hopefully listens in to the parties. And they are also able to find solutions outside the strict legal formats. But I would like to describe it, and this is perhaps because I'm specialized in contract law, I would say that this is a kind of contract whereby the parties agree that their contract can be amended and that this will be made by the help of the board members. So they agree to change or supplement their agreement in when a certain formal procedure has taken place. So I wouldn't categorize it. I'm sorry, I wouldn't categorize it as dispute resolution.
And I think it's leaning towards a lot of that. It is a hybrid model. If we look at dispute boards, it is a hybrid model. And before we explore how Christina kind of unpacked this, is it purely resolving a dispute or making a decision on a dispute, or is it something else of modification, agreement to modify your contract? I'd like to maybe look at the tools. Are there any other tools being used in Sweden, like mediation, like the ombudsman, or like there's a wide spectrum of possibilities and alternative dispute resolution before we get to the dispute boards. Are there any being used that are familiar to the Swedish market that maybe we can use that as a jumping point to help better understand what dispute boards are and introduce this concept? Jürgen?
Yeah, if I may just add to what Christina said. I mean, to me, as I said, being a rookie concerning the adjudication world, although I've run across it, and I know that it has been well developed in certain areas, for instance, concerning construction, major construction projects. It's still I'm still a bit confused about the toolbox, because people are talking about adjudication, and to add to that, we're talking about dispute review boards, dispute adjudication boards, combined dispute boards, etc., as in the ICC rules. We're talking about expert determination, emergency arbitration, early neutral evaluation, etc., etc. And to me, I mean, there could certainly be a difference between these tools, but it all or very much depends on the arbitrator, the neutral, or whatever you call the person, the mediator involved in this, because it is actually what you want it to be. So I think it's difficult to put a label to it. And I think that from my experience, we are an underdeveloped country when it comes to using these tools. I would say that generally, at least, maybe not in the construction industry, but generally we are. So I think we have a lot to learn. We have an experience factor to gain, because I think we look at this with a certain suspicion. And I think that's the reason why we normally tend to use the normal tools. And that would be normal arbitration, or it could be fast track arbitration or express arbitration, as we have, as now SSE introduced last year. And I mean, express arbitration is not really an arbitration to my mind in the ordinary sense. So the express arbitration would, to me, be a kind of 4-stage to an arbitration, or could be a kind of mediation, could be a kind of an expert panel, depending on how the neutral works.
Yes, and I think I'm going to draw a few threads here from what I've heard from Christina and Jürgen, and maybe kind of put a frame and see if you agree with that frame, and then turn it over to Kai to see how that fits possibly in the construction industry. So if we look at, we heard the term mediation, where you have a neutral facilitating a dialogue and helping the parties reach their own agreement. We had arbitration, where you have a decision maker that is empowered to make by the parties and law to render an award, an arbitration award that becomes binding on the parties under a legal framework. If we go between those two and look at dispute boards, they can be, Jürgen mentioned this DRB or dispute review board. This is, like Christina said, it is a creature of contract where the parties agree that this third party neutral is going to, in a certain circumstance, under certain procedure, give them a recommendation at the end of this procedure, this agreed procedure. They will empower that neutral, the dispute review board member or members, it can be a panel of 1 or 3, to be inquisitorial. They can empower that in that panel to adopt a role of a facilitator. They can empower that neutral before they make the recommendation to act a bit more like a mediator and have individual caucuses with the parties. And at the end of the day, give a recommendation that is only binding upon the parties if they agree for it to be binding after the recommendation is issued. And like Christina said, it's not something that is legally enforceable outside of, it's an agreement of the party. Yes, Christina.
Well, I guess you could choose an option where you say that there will be a recommendation and it's fine if you like it, if you agree. So it's merely the outcome is really only a recommendation. But you could, of course, construe the contract so you say that I declare beforehand when we conclude the contract and include this dispute resolution board that I will be bound by any decision from the dispute resolution board. That is binding.
Indeed, Christina.
But however, I can't enforce it unless I get it confirmed by an arbitration
Indeed, and this is what FIDIC chooses to do. They don't use a dispute review board, they use a dispute adjudication board, where they empower this neutral to be an adjudicator, to hear the parties and decide the parties' dispute. And within this contractual framework, the parties agree to be bound by the decision of the adjudicator or the dispute adjudication board. So that decision is binding once issued, but it's temporarily binding on the parties. So if they under the contract, they agree to be bound by it. So it would be a breach of contract to not give force to that decision. You can possibly, I think we have a lot to explore within the hour, and but you can, which FIDIC does, connect it to arbitration so that it can be enforced through arbitration in case parties don't comply. But that is the next level of the dispute. So now we start seeing, we have two possible options of this dispute board. A dispute review board gives parties a recommendation that they can like it, or if they like it, they can use it. If not, it has no effect, legal effect. Or they can use a dispute adjudication board, and they empower the dispute board to make a decision that's temporarily binding, and it's a creature of contract, and it would be a breach of contract if they didn't comply with it or they didn't give force to it. Kai, I'm going to turn to Kai for a minute here, because for him it's not theoretical. For him, he's been involved in a lot of these FIDIC type of contracts, and if I could give you the stage, if I can ask you to introduce the audience maybe a bit to the FIDIC dispute resolution system and how dispute boards fit in, and how you've experienced the use of dispute boards as a practitioner in the engineering construction space.
Yes, thank you. How many hours do I get?
Yeah, well, you get the point. It's a fraction thereof.
Yeah, but I think it's good for the audience to, because perhaps not everyone is crystal clear with the FIDIC, but very brief. Coming from the construction industry, we are the international construction industry. We're blessed, I would say, to have a 60-year-old experience and documents representing probably the most recognized works contracts form there is globally in the construction industry through FIDIC's different contract forms. And it's everything from a construction-only document over to design and build, the EPC contract forms, and now FIDIC is producing even advanced design, build, and operate forms. So it's quite advanced, and it's well recognized, well tested and tried, I have to say. And in those forms, and I was, like Aisha said, I've been on the board of FIDIC for several years, and I actually joined the contracts committee because I thought it was such a good cause and purpose, and also very stimulating to work with. So I was on the contract committee for some years when we delivered or produced the latest edition of the most used FIDIC forms, which is called the Rainbow Switch, which is the red, yellow, and the silver book. And in those forms, the dispute resolution mechanism has, how can I say, improved is probably not the right word, developed from being a dispute adjudication board to now being a dispute avoidance and adjudication board. And I have to connect to Jürgen's comment when you say, what is this? And there are so many different forms and so on. And that's a good comment. But the kind of, the good thing with the FIDIC tools, if you like, is that it is highly recognized by the industry. Your questions, Jürgen, are never asked in the industry. What is this? How does it work? What does it do? What status does it have? Because it's so well established. And I think another very important view of it is that the mother body, FIDIC organization, FIDIC, has a list of certified possible dispute board candidates, which the parties can turn to. And it's kind of, they get a quality assured individual who can take on the role as the dispute board member. And so I don't think, I've never experienced that there has been a question with the credibility of the skill set of these board member candidates, which kind of gives gives a quality and a credibility to not only the members, but the whole system, the document, the condition, the general conditions that the board is procured on, the procedure they are to work along with, and their individual and their skill set and experience.
Yes, and so what FIDIC does, the FIDIC dispute resolution system, as Kai was talking about, has a possibility of having this dispute avoidance and adjudication board. And what FIDIC recommends and mandates in the 2017 suite is that that board is constituted at the beginning of the project. And that board is seen as a standing board and is stood up at the beginning of the project and stays with the entire project. So when Jürgen says, what is the function of this board? That board has two primary functions. The first is dispute avoidance and giving and helping the parties deal with issues in a real-time manner as they arise. And that board is empowered to, when asked by the parties, is empowered to give an opinion. So if there's a provision of a contract that the parties are at loggerheads on the interpretation or the application of that provision, they can approach the board, who is informed and who stood up at the beginning of the contract, to give a reasoned opinion that's not binding on the parties, that's not binding on the board, to say, this is how this would most likely be applied. And so it gives a possibility for the parties to align to, or to realign their expectations with the reality of the contract on a real-time basis as these issues arise. And that's the dispute prevention or dispute avoidance function. The dispute, yeah, Jürgen, please.
Sorry, I think that you are coming from where I'm coming. I just note that I think you are much more developed in the construction industry than what I'm used to. And I guess that part of the reason why it works so well is that, well, you have a well-recognized system that people knows works out. But I also think it's linked to the fact that you have, in typical construction projects, you have a lot of processes, you have a lot of procedures between the parties who are involved, a lot of meetings and quality controls, etc. And I also think that there is an interaction between the parties in a much closer way, I would have guessed, than in a typical. I'm thinking about shipbuilding contracts. I've done numerous shipbuilding contracts, both contracted them and also been having arbitration or disputes revolving around them. And there the situation is partly different, because even though there are some processes in a shipyard as you move along, it's much more rudimentary than what I expect in the construction industry. And the further problem I see there is that often the parties in a shipbuilding project have a much clearer hidden agenda. I mean, that could be for the shipyard, for instance, that they don't have the funding for the project when they start, i.e. they have to put up some things on the claims agenda, like variation orders, like delays. I mean, they are bound to it. Of course, they say nothing about it. You may have technical issues that are not resolved when you start a project. You have to solve them as you walk along. You may have difficulties concerning supplies. Typically, a main engine which takes a lot of time before you get it to a ship. And there may be difficulties concerning drawings moving back and forth. And I find that one of the problems is that the parties don't want to play with open cards. So in that context, I'm trying to see what the dispute education board could do, because they wouldn't see the cards, the parties wouldn't play them. And one further point would be that one of the parties have a huge advantage over the other, because there would be, during the building project, one of the parties, the shipyard, would have all the documents, all the facts, whilst the other side will have very, very limited facts. So it means that if you start playing the cards to a mediator or to an expert during that stage, one card would sit with all the cards. I'm just making this comparison, not to say that we shouldn't use this in the shipping world, but I'm trying to figure out how that could be developed, since I do appreciate that it works very well in the construction world.
Yeah, I'm gonna start and then I'll turn it over to Kai for a moment, and then I'm gonna ask Christina to talk about shareholder agreements, and I'll tell you why I've gone in this direction, in this approach. You mentioned a number of things: exchange of design, variation orders, being ready to, you might have bid low and you have a claims package of a health program as a shipbuilder of how you're going to get healthy, and you don't really want to talk about that to the ship owner right now, but you want to be able to, through variation orders, make yourself a bit healthier. Everything that you've talked about is part of, I think, is recognizable in the construction industry. But if we take a step back, and I think why is it that the construction industry has this mature approach to deal with disputes, is because the reality is, if you're going to get anything built at some point in time, these are long-term projects. Risk is inherent in construction, as it is in shipbuilding, in every stage. And while there are players that might not want to reveal their cards, but in the first instance, contractors want to make money. They want to do a good job, but they want to make money. And employers want the final capability, whatever that, they want a hospital, they want a hotel, they want a power generating facility, they want a ship. And it was found that if you actually address the issues as you went along, that the project would succeed in a shorter, more expedient time. And in that, both parties became healthier and actually achieved what they wanted in a more positive fashion. So when they turned their focus on project success, they both achieved their individual, maybe different needs. And that is what I have found has led to the maturity of dispute resolution / avoidance in the construction industry over the past 60 years or over the past 100 years, because tiered dispute resolution in construction is not new. Kai, does this resonate with you, what I'm saying?
Yeah, I was laughing because when have we ever sit down and kind of picture the construction industry as the most fair and balanced and tidy industry when it comes to contract?
Reveal all the parts.
Yeah, but I very briefly, I should say about the same thing as Aisha said, but from another angle. And I think what the difference is to the shipping industry maybe is that shipbuilding industry maybe is that at least when it comes to the FIDIC approach, drafting these contract forms, is that they kind of put an attitude to it that both parties recognized the known unknowns. There will be unknowns coming up, and both parties recognize it from the beginning. Whereas in the shipbuilding industry, sounds a little bit more that the employer is holding the cards to them and the builders is holding the cards to them. And if you look at the whole dispute avoidance toolbox in a FIDIC contract leading up to the dispute adjudication board, there are other tools even before the dispute adjudication board, starting with an actually well thought through, fair and balanced risk allocation between the parties in the contract's general conditions, followed by this, which you don't know about, but there is a certain individual called the engineer who is actually there to determine possible issues that might end up to disputes, and then ending up with the dispute board. So the whole kind of ambition and setup is based on, yes, there will be unknowns, and we know it, both parties starting off.
And when we talk about there will be known unknowns, and we have to deal with them as they arise. Christina, does this sound like a bit like maybe a possible contours of a shareholders agreement? I mean,
yeah, there are so many agreements nowadays. It's actually quite modern phenomenon. The fact that we are collaborating with contracting parties on a long-term basis. And the idea is to create a win-win on a long-term basis. And we have I think it's very well put, the future is uncertain. And when we conclude the contract, we know that we cannot foresee the future, but we're making we're dependent on each other. And we understand when we conclude the contract that we need to both gain money out of our collaboration. And we can try to deal with these matters in force majeure clauses and hardship clauses. And we can say that, well, we can foresee that probably there will be some changes or some need to adopt in this aspect. And then we can try to find formulas for that. But you can be sure that if it's a long-term contract, these formulas to make the changes will tilt one way or the other, and that is detrimental to the overall purpose of both of us gaining money on a long-term basis. And I'm very interested in shareholders agreements. Why not having a dispute resolution boards and what we see in shareholders agreements when the parties start to quarrel, it's a lose-lose-lose situation that we may perhaps avoid by creating dispute resolution boards tailored for their specific needs. We have outsourcing contracts, we have other joint venture contracts, distribution and license contracts, research and development contracts, etc., where we need to find a way to make the relationship more flexible.
We did have a comment from the audience, and coming to you, Jürgen, right away. We had a comment from Anat Quale in Kavalev in Finland, talking about the use of these dispute boards in energy contracts. And John Papworth in England was mentioning the dispute avoidance function, or trying to say we should highlight the dispute avoidance function. But Jürgen, I want to come back to you and see, you had a comment.
Yeah, just a few thoughts. First of all, coming to other areas than shipping, as I refer, or the construction industry. I mean, the offshore industry is of course also within the construction industry, and I'm just reminded that, I mean, there have been sort of dispute education type of clauses in the standard contracts in Norway since the 1980s, when I started working with the offshore contracts there. And then, just because I'm trying to sort of figure out how we can better use and develop this in other types of contracts than constructions, because you are more mature there, I would say. And I think there are two, I wouldn't say problems, but two challenges. First of all, typically when we negotiate contracts, we start on page 1, and then when we come to page 40, then we come to the dispute resolution clause or whatever we call it. And then we're so tired that we use a standard clause, full stop. I mean, we don't even think about doing this in a very scientific way. Secondly, I think that if we turn this around and would start with the dispute resolution clause and combine that with Kai's comment, namely that don't play your cards against your chest like this, because you have a common interest to make the project work, whether it's a shareholders agreement and you have earn-out issues coming after the shares have been transferred, shipbuilding contract or whatever. And I think that if the parties sit down and have an open discussion, what's the key concerns? Because there are always key concerns. What's the critical path going to look in this project? And then I'm sure that in many type of contracts, you would be able to narrow down the scope for disputes. So you don't have to open the door for everything. I mean, you can say that concerning this and this type of issues, we know that they would come on the table or there is a serious risk. Let's place them with an expert or whatever we call it. And then, of course, you can always discuss whether it should be binding or not, whether we should make it in an arbitration award so it's enforceable. But I think it would be a great step in many contractual relationships, not necessarily within the construction industry. If you take that step, have that serious discussion, and then I think we could learn a lot. We being outside the FIDIC system normally, we could learn a lot from you, because obviously you've done this for years.
Yeah, and I think the key, going back to, I like Christina's comment about win-win on a long-term basis. For these parties that are going to come together and for them to win-win on a long-term basis, they are going to have to devise a system of being able to surface issues that are festering, if it's repricing, or if it's a force majeure issue, or if it's a design defect, or they're going to have to be able to surface it and discuss it and deal with it such that the project can continue. And you can use various tools. You can have a formula in the contract that says this is your repricing formula, or you can have somebody like the engineer to give you the first look, or you can have, so it's increment, it can be incremental. And the dispute board can be a dispute review board, is part of that incremental thinking of during contract execution of a long-term project that has known unknowns, like Kai was saying, and that what Christina was saying, you want a win-win on a long-term basis. Well, when those unknowns become knowns, how do you deal with them? And in my experience, I think we have to say that contracts don't operate themselves. People operate the contracts, and people come sometimes with emotions. And so having that standing neutral sometimes helps focus the individuals on the problem at hand and finding a solution on a real-time basis. So, but I think one question that I would say is, when you're devising whatever these incremental steps are, from a legal perspective, how best to make the transition from ADR, you've always have to think of how you're going to make this a positive experience. How do you make that transition from ADR to either litigation or arbitration? And Christina, and then Jürgen, maybe over to you.
Yes, I have a very strong opinion on this matter.
Oh, okay.
So the dispute resolution board, whether it creates a recommendation or a decision, it is not arbitration. So whatever they do, it cannot be enforced. And we want it to be enforceable. So then we need to have arbitration as a last resort. But we don't want arbitration because that's costly and time consuming and everything. But if we know that the arbitral tribunal will decide that, Aisha, you have to pay me 10 million. We know that for sure. Then of course, Aisha, you will not put in a request for arbitration. You'll pay me the money. Okay. So we want the arbitral tribunal to be bound by the decision from the dispute resolution board. Now, how can we achieve that? By not giving any instructions to the dispute resolution board. Don't make a description of a formal procedure in front of the dispute resolution board. Simply give it a mandate to come up with a decision that the parties must obey. Nothing about meetings and drafts and submissions and hearings and who or whatever. Be as short as possible, because the only way that the arbitral tribunal can overturn the decision by the dispute resolution board is if it has not followed the instructions. So the more instructions we have, the greater is the chance that Aisha will put in a request for arbitration instead of just paying up. So this is my firm recommendation. And I think this is a bit contrary to how people normally perceive things, because when they draft the contract, they would like to describe how the dispute resolution board should function like a manual. Don't do it.
Kai, you're smiling. Do you have an opinion on this? I know what FIDIC may be saying to some of this, but Kai?
Well, as I said before, FIDIC has a clear procedure for how the board should work, I'm not going to change my mind. I'm going to stick to what I said 30 minutes ago, which I think that's part of the power in the recognition of the dispute board's work and decision. I think I know that the arbitration tribunal is allowed to open up the dispute board work, right, and look into that. Now I'm on thin ice, but
you're absolutely right. As long as it's when it's not final.
Yeah.
If there's a notice of dissatisfaction, they can open up the whole dispute review board decision.
And so my strong opinion based on experience is that the more professional, formalized the board procedures are, the more likely it is that its decision is getting more recognized and hopefully not ending up in notice of dissatisfaction. But that sticks with the construction industry only.
Yes, and I agree with you. When the board only comes up with a recommendation, then I think you're absolutely right that we need procedures in order to make it more legitimate, the recommendation. But if we have a dispute resolution board with a decision that the party has already beforehand undertaken to follow, then there should be no formalistic requirements on how the procedure is designed.
I will say one thing to this, and maybe just to be a little devil's advocate, Christina, on this, because and speaking again from the construction industry, one of the problems with the construction industry is cash flow. If you don't, it's a bit pay now, the need of pay now and argue later. So we want, like my first boss said to me, a 70% decision that's right, 70% correct decision now is better than 100% correct 5 years from today, because 5 years from today I may be bankrupt. I need to move on. So the idea of these temporarily binding decisions that are still open to recourse to being overturned in a deeper focus with due process in an arbitral setting, like Kai said, that are capable of being totally open up and reviewed under arbitration, is that you want the payment now, but you don't want that where the money sits to be permanent. You just want the cash flow to continue, to keep everybody in a going concern. But you also don't think that every decision is capable of being made in being determined within 84 days or 28 days, however that adjudication goes. So you want the possibility of me paying you 10 million, which I really don't want to do today, but yet having a more robust look at the rights and obligations of the parties to determine if that was actually really the right decision, or should have I paid you 5, or really you need to pay me 8.
Yeah, I agree with you, Aisha, and I understand that what we want is quick and dirty.
Yeah,
we want quick and dirty, and we don't care that much about the quality. And then you say we can accept quick and dirty and perhaps a little bit less quality if the decision is only temporary. Okay.
yes.
Then just to be provocative.
Yes, we are.
Why make it temporary? Why don't stick with the quick and dirty forever? As you say, it's 70% right. I am a bit worried that when lawyers, Kai, you may agree, when lawyers get into the picture, we are obsessed about a fair trial. And we're not obsessed with the business needs of quick and dirty. So I'm just provoking you now, Aisha, and say, why only temporary? Why not quick and dirty forever?
I think temporary is what the business decision also wants, because there are times where, not without the lawyers in the room, that the parties themselves are willing to do a deeper delay analysis, but I need cash flow today. So it's not only the lawyers that drive this, but I think you've touched upon something here, because the solution needs everybody around the table, needs the engineers, needs the business people, needs the CEO, needs in-house counsel, needs and when we're getting into a design and build or shareholders agreements, we need all these interests reflected as we're making decisions along the way. And we need those voices heard along the way. And having a neutral that is aware of all the parties is another aspect of having a standing board that is available as a neutral with this long-term execution that can hear all those voices. And one of the comments that we've heard from the audience is that the dispute board member is empowered under the FIDIC conditions to set their own procedure for every dispute that needs to be heard. So it isn't that FIDIC sets the procedures, but the agreement empowers the dispute board members to set the specific procedure to address the parties' issues, if it's an opinion or dispute at the time, in a fashion that is appropriate. So you're not trying to resolve an issue with a sledgehammer, to pound a nail with a sledgehammer, but tailoring the procedure in an appropriate fashion to have quick and dirty, but also confidence in going forward. Because one of the other facets of construction is many of these players are interdependent on each other, and it's not only one-time relationships as well. So you want quick and dirty, but you also need to save relationships along the way. And one of the aspects of these dispute board decisions is that they're reasoned decisions. So when you sit as a dispute, you don't just say, pay 10 million. You say, you walk the parties through, and you almost give them like a little roadmap or a manual in your reasoned decision of how to help them, enabling them to make the next decision on their own. Which, Kai, do you have experience in reading dispute board decisions that you found helpful to the parties to help guide them in better administering their contract?
Absolutely, a lot. But I think Jürgen wanted to say something. He's been waiting for a long
And
time.
I'm there. Thank you, Kai.
No problem.
I
Thank you,
applaud
Kai.
Jürgen.
Yeah. Now, I was just considering why this works out so well in the FIDIC world, because I think it's very nice to hear that. And I think you gave me the key word, Aisha, because I was just thinking about whether one of the main reasons is that the parties have, I mean, they have a long-standing relationship within the project, but they may also run across each other in another project within a year or so. So, I mean, the parties involved are sort of involved with each other one way or the other, or they may connect in another project in another country or in the same country within a year from now, which makes it much more natural for them to sit down and try to resolve things, because they would need the liquidity. They would need to be nice to each other in order to develop a good relationship, not only for this project, but also for the next one. Because I'm a bit intrigued, because I've been involved in so many rather very aggressive international arbitrations. For instance, linked to gas distribution from Russia to Ukraine, which is on one issue today, of course, in this horrible world. And my picture is that when we lawyers get a chance in an international arbitration to question something, we will definitely do that. And that also comes to dispute resolution clauses. I mean, every sentence you write about how to resolve things, every procedural instruction, everything will be turned up and down 15 times, because people will try to just knock it down and say that this is unfair, it's unbalanced, etc., etc. So it's a sort of there are so many issues revolving around this, and I was just thinking that when I was reading the FIDIC dispute education clauses, because I can see 50 things that I find ambiguous in the wording, and I just felt that it works must mean that people want it to work. Because if you don't want that type of clause work, I can tell you it could be shut down in 5 seconds.
There are absolutely places where people do want it to work, and the fact that it is supported by the multilateral development banks, and where you're looking for a win-win on a long-term basis. I'm borrowing Christina's words again, because so there are areas that have been ambiguous, and I don't know if you're reading the 1999 clauses. There have been improvements in the 2017 clauses or enhancements, but whatever multi-tiered dispute resolution clause that you use, or whatever dispute resolution tool that you use, I think every tool is breakable, including arbitration. So, and if your focus is, and I think this is the mindset part of Christina talking about the lawyers, make it binding and don't give procedure, because once you start talking about procedure, then the natural focus is, where do I break this? How do I break this? And so it's coming from the vantage point of making it work. I was monitoring the chat, and I see some comments. There's a comment from Anton talking about having a dispute board comprising senior members from the engineer and from the contractor to listen to comprise the dispute board. And there was a comment back saying this is like a mini trial, it's a great idea. But the key is there's tools and you can tailor these tools to the needs of your long-term project. And the way FIDIC has done it over the past 60 years works in the construction industry. It's known to the participants. But the dispute boards are used, like Annette had mentioned, in the energy sector. And what we're trying to do here and we're just starting to scratch the surface, is just to provoke some thought and see how is it? What is it? Like what you were saying, Jürgen, what does this do for me? When do I use it? How do I use it? I can break this in a small second. This is not durable. But what are the possibilities? And I know this hour has flown by, and I see that Annette is saying that you should focus on that dispute board decisions are seldom overturned, and the DRBF statistics quote 90% continue. They stay and they are not overturned. So there are some arguments, and we're going to have to spend another hour or two or another day or two. But before we close, I want to just give each of the speakers a minute or so to kind of to share their closing reflections or closing thoughts. Jürgen, first to you.
First of all, I've learned a lot during this conversation or debate because I think that it's very impressive what you have managed to achieve within the FIDIC system. And I think that it could be applied in a much larger scale in other areas as well. I think it could be quite suitable for that. But I think we have a learning curve, we not having been involved in that type of dispute adjudication processes. But I think that the thing I mentioned is the key for me, or the key takeaway, that perhaps the next time I have a shipbuilding contract or another type of contract, maybe why we should start to negotiate the dispute resolution part first. And in combination with a true analysis by both parties, what are the key concerns we have? Where do we see that there will be issues coming up that we don't see right now, but we know that there will be some kind of conflict? Because I think in many projects you can target that and go from there and see if you should have a more general dispute adjudication clause of some sort, or whether you should do something else.
I'm gonna turn it to Christina.
I'd like to fully echo what Jürgen says in every respect, and to dare to start the negotiations on a contract, saying I want to gain money from this contract and you need to gain money from this contract, and how can we make sure that we both gain money by being transparent or acknowledging each other's potential problems, etc. And then after such a discussion, I think the dispute resolution board may be a way to ascertain this.
Kai.
Yes, first of all, I'd like to say I think we forgot something, Aisha, and that is, of course, to break the board procedure is not an issue, because the FIDIC conditions have actually been reviewed, almost approved by industry association representing all stakeholders that are affected, including even financing, insurance industry, engineers, of course, contractors, and so on. So it's kind of a deal. We made an agreement already. These are the conditions, and we are agreed upon. My final comment is actually preceding dispute boards, because at the end of the day, we want to avoid disputes. And what I see when I'm part of disputes and advising on boards, what always comes back to my mind is that in the construction industry, where we have the opportunity of picking different delivery model contract forms, the main problem that I see is that a few projects, I don't say it's the employer doing it, it might even be the financier, but a few projects, the wrong form is used for the wrong project based on market conditions rather than project characteristics. I've seen so many projects that are suitable for even a red book build only that they're trying to squeeze into a silver book EPC. And well, guess what? They end up even beyond dispute boards. So if there are people listening from the construction industry, that's my takeaway, really.
Yeah, I think in listening to everybody here, I have two takeaways. And one is that the parties need to have a starting point by being transparent and really focusing on what they are trying to achieve from this relationship, from this contract. And then structure their agreement, if they're going to use a standard form, or from a bespoke form, by structuring their agreement appropriately so that they can have the right, so that they can actually achieve what they want. So that they first focus on, I want to make money, you want to make money, we want to build a road. We know that we're going to have problems. How are we going to address these issues along the way? And let's set the terms clearly and set the proper terms so that we can focus on the best success. And so using the right form of contract. The other takeaway that I see is that we've had an excellent discussion, as I see from the chat and the comments that I'm getting from the floor. But we're just scratching the surface. And this is the role of DRBF as the Dispute Review Board Foundation. It's a US-based organization, but its function and its purpose is to education and collaboration on the use of this dispute board concept. And I thank the speakers for this invaluable discussion that we've had today. And I selfishly invite them back for our next series of webinars. And I hope that they will, accept to rejoin us and to continue this, I think, very worthwhile conversation. But I take the opportunity to thank the audience for listening. I thank you for your comments. I noted we didn't have any questions, but I tried to integrate the comments as we went along. And I just want to thank the speakers very warmly and wholeheartedly for their time and for their invaluable insights and for this much appreciated dialogue.
Thank you, Aisha, for great chairmanship.
Thank you.
Absolutely. Thank you.
Thank you very much.
Thank you, Christina. Thank you, Jürgen.
The
Thank
conversation will
Thank you,
continue,
Christina.
and dispute boards in the Nordics will be having the roundtable on Finland in April. So we hope that you will join us then as well. Good night.
Thank you. Good night.
Bye-bye.